The summary approval procedure now effectively standardises whitewash procedures that were previously available. It can be used to validate 7 activities: financial assistance, reduction of share capital, capital variation on a reorganisation, the treatment of pre-acquisition profits, prohibition of loans to directors, mergers and a member's voluntary winding up. The summary approval procedure can be used by private companies limited by shares, designated activity companies, companies limited by guarantee and unlimited companies. Public limited companies can only use the procedure in limited circumstances. A private company that is a subsidiary of a public limited company cannot utilise the procedure to approve financial assistance for the acquisition of shares in a parent PLC. Three types of domestic merger are now available. They are merger by absorption, merger by acquisition, and merger by formation of a new company. The directors will need to prepare common draft terms of merger. There are some exceptions, but an expert's report will be required and the merger will need to be approved by the members of each company. This is a process whereby an existing company acquires all the assets and liabilities from one or more companies in exchange for the allotment of shares to the members of the transferor companies. This can be with or without cash payment. The transferor companies are then dissolved without going into liquidation. This is a process whereby a wholly owned subsidiary transfers its assets and liabilities to its holding company. As a result of this process, the transferor company can be dissolved without going into liquidation. This is a process whereby one or more transferor companies transfer their assets and liabilities to a newly formed company in exchange for the allotment of shares to the members of the transferor companies. Again, as a result of this process, the transferor companies can be dissolved without going into liquidation.